Be
Evidence.
quiet.
This is my hearing and I'm allowed to speak at my own
But
hearing.
I have to let you know, I'm arraigning you. There
You're
was
reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interest in his executive order that he recently put out.
All right. So
Are you Article?
Is that you stopped Mr. Nurswick's mail? You were interfering with his mail, Ms. Nurswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that appears.
You do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Welcome back, Courtroom Chaos fans. Buckle in, because this hearing is not your average legal showdown. We're diving into part 4 of the Lindsay Deskey disaster, where sovereign citizen theatrics meet courtroom reality. This time, Lindsay rolls. In fresh off a resisting arrest charge after refusing to get out of her vehicle during a traffic stop with an active warrant. Mind you, the courtroom tension, nuclear. She's armed with Article 3 court demands, misquoted statutes, and her signature sovereign citizen rants. But today's judge isn't playing, and neither is the prosecutor. Will Lindsay finally face consequences or keep spinning her web of confusion?
Unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Stanowski, I'm going to put you in the breakout room with Ms.
This is a violation of my Sixth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me.
Classic SovCit move. I wasn't properly served. But here's the kicker. Michigan Court Rule 2.107 says, you're legally served if it's sent to your last known address. And guess what? Lindsay moved out and failed to update the court. So no, it doesn't matter that she wasn't living there anymore. Ignoring legal obligations doesn't exempt you from them. It just makes you look reckless in court. This isn't. DoorDash, you don't get to choose when and where the law delivers consequences.
Come back. I have a 2 o'clock in
I don't need an attorney. I don't consent to an
Yeah, I
attorney.
can't. I don't have a prosecutor. I need you to come back. What about
Prosecutor.
2:30?
I want to say something. You guys are. I've
Miss
talked about
Williams,
Your Honor, I'm talking to
5 days.
I
I've been
have
here
no
5 days.
prosecutor.
I was
I
not
got
even
you.
notified of this court. I was not even given notice of this court date, and I've
Yeah,
been here.
so
5 days.
Mr. Ness, please
let's say
be quiet.
1:45. I don't have a
You
prosecutor.
don't need to
I
be
can't
quiet.
do
This
anything.
is my hearing.
Can we do 1:45, officer?
Yeah, 145.
Okay.
All right,
I'll
we'll
be
see y'all
back at
back at
1:45.
1:45.
Okay, thank you, Your Honor.
Bye-bye.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that that hearing would be done by 2:30 or are
I'm
we
waiting
looking
on the
at
prosecutor. I can't.
Well, it has
The
to go,
record is
Your Honor,
going
I have
now.
a 2
I
o'clock.
can't call
I
it.
need
So
a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why
Okay.
won't you
Thank
answer
you,
any of my
Your Honor.
questions?
Mixed with a sprinkle of Trump executive orders. Lindsay claims the judge has no authority unless they're Article 3, but this is a state court, not a federal one. And citing Trump's orders like they override state judicial structure. That's not how jurisdiction or reality works. Also, invoking her kids as her liberty interests might be the most sovereign citizen thing ever. She's basically turned a custody case into a constitutional war zone.
Yeah, this one, I think.
Considering the fact that, you know,
Yeah,
I've been, this is, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-born arraignment.
Hold on. Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, House Counsel on behalf of Mr.
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And
Certainly.
I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a
For what?
warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
And let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation,
Six.
which 2.516.
No,
does
two,
appear that
I'm
is a
sorry,
rule of-
2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures, this being a quasi-criminal matter.
This is a
Does,
civil procedure because it's family court.
Hold on, Ms. Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need.
Lindsay threatens the judge with the death penalty under USC 18241 and Section 242 statutes about deprivation of civil rights under color of law. But these laws are meant for systemic abuse by government actors, not judges, doing their job. Lindsay has turned sovereign citizen bingo into a one-woman horror film and threatening public officials. That's a federal offense. Someone get her lawyer.
Proceedings, this matter being a quasi-criminal proceeding, does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Mr.
Oh, okay.
Okay, go ahead,
Your
Mr.
Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He's saying your court rule, he's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter. It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code also. The reason why I looked up the.
I'll give you an opportunity to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry, the allegation that you violated a PPO.
Okay, well then I have a right to say was not notified.
I'm going to give you that opportunity, but you have to. The allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office, speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument. As it relates, I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate.
I'm proceeding sui juris and persona.
Well, I am going to ask Ms. Fort Williams.
Lindsay explodes into a sovereign symphony. She yells about kidnapping, torture. Treason Ann claims this case violates just about every constitutional amendment ever written, including a mysterious EFD amendment that doesn't even exist. It's like watching someone read the Bill of Rights upside down while auditioning for a courtroom soap opera. The most tragic part: she genuinely believes this delusion is legal strategy.
I don't want an attorney. I do not want an attorney.
Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I asked Ms. Fort Williams to stand by. She's just going to stand by.
Even though
what else would you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, Lefty versus McVicker, I can challenge us at
For
any
purposes
time.
of what
At
she was
any
saying,
time.
Your Honor, Mr. Nesky, you have to be.
She insists a prosecutor has no place in a civil case. But here's the twist. Violating a protection order can escalate a civil case into a criminal one, which is exactly what's happening. She demands a Cold War tow, presumably some sovereign citizen. Version of a legal trial land throws a fit because no one answers her mid-rant questions. Imagine if courtrooms ran on tandem.